Good morning and good afternoon to everybody watching this webinar from all over the world. Today we're going to be looking at contract management and dispute resolution. And this webinar is brought to you by Nishith Desai, the Law Society of England and Wales, and UK IBC. My name's Chris Hayes. I'm one of the directors at the UK India Business Council. We're a strategic advisory and consultancy business, and we solely work on the UK-India corridor. I'm currently sitting in a little bit of a gloomy London. Weather is about 17 degrees, so abnormally hot for this time of the year, and you'll be glad to know it's not raining for once. It's my pleasure to introduce our speakers to you today, but before I do, I wanted to just set a little bit of the scene. The recent meetings of Prime Minister Modi and Johnson and the announcement of the £1 billion worth of new UK-India trade and investment, including around £400 million of new export deals for UK companies, shows the commitment of the two countries to increasing trade and investment. This meeting also set out the enhanced trade partnership and a 10-year roadmap to double trade by 2030. There was also a commitment to deepen cooperation in a number of key sectors, including educational services, healthcare, which is obviously extremely important to the globe at the moment, and food and drink, as well as a pledge to remove barriers in the Indian legal services sector, another step that could significantly increase trade and collaboration between the two countries. The Prime Minister also announced the intention to open free trade negotiations, and Mr. Goyal and Ms. Trevelyan met last week in Sorrento to accelerate these talks. At UK IBC, we've been working very closely with the Department of International Trade and the Indian government on a consultation that looks at how this free trade negotiation should commence. Our recommendations included the government should seek a series of mini deals or interim agreements that over time would develop into a more comprehensive free trade agreement. We also recommended there was an early harvest agreement to reduce tariffs on a number of limited sectors, as well as reducing non-tariff barriers and aligning standards. And finally, we recommended that the agreement should also look at IP protection and the alignment of data protection rules. These recommendations would allow trust to be built and for businesses to see tangible benefits year after year, rather than a single comprehensive agreement which might take years to negotiate. Some of you recall the EU and India spent 13 years negotiating a potential free trade agreement only for it to fall at the last hurdle. So a series of mini deals would see those benefits reaped a lot earlier. Our flagship Ease of Doing Business report constantly shows that bureaucracy and legal issues is one of the biggest barriers for UK companies doing business in India. And our latest report on this will be released next week. So why is this important, and what does it all have to do with contract and dispute management? Simply put, moving from a £24 billion worth of trade to £50 billion worth of trade will mean greater cross-border collaboration, new partnerships, new joint ventures, and of course, new contracts that will all need to be managed. I'm delighted to welcome a fantastic panel to take us through some of these key areas when you're negotiating a contract in India, some of the recent developments in Indian law, and of course, the growth of arbitration and mediation in the Indian market. Firstly, I would like to introduce Harish Salve, Senior Advocate and Queen's Counsel. Harish is one of the world's leading arbitration counsellors. He is very experienced and a senior lawyer with a global reputation for international commercial arbitration and litigation. Harish was admitted to the Bar of England and Wales and was appointed a Queen's Counsel in 2020. Harish was formerly Solicitor General of India and a senior advocate at the Indian Bar, practicing largely in the Supreme Court of India. In 2015, it was announced that Harish had been awarded one of India's highest accolades, the Padma Bhushan. Next, I would like to introduce Dr. Sharina Petty, an Associate Professor in International Arbitration at Stockholm University and a qualified attorney in law. She has over 17 years of practice in international commercial and investment arbitration and international dispute resolution. Sharina is also a director of LLM in international commercial arbitration law at Stockholm University. Our next panellist is Sharina Petty, a partner in the London office of Norton Rose Fulbright, where she leads the practice across Asia, Europe, and the Middle East. Sharina is from India, so has an added interest in this webinar, and she also heads up the firm's India practice. Besides arbitration, she has significant experience in investor-state dispute resolution, alternative dispute resolution, and litigation. In addition to acting as counsel in arbitrations, she regularly sits as an arbitrator. Sharina is also a very active member of the India desk of the Law Society, one of the partners for today's event. The Law Society is an independent professional body of solicitors in England and Wales, which supports solicitors to develop high standards of service to their clients. It has about 190,000 members operating in the UK and overseas, of which 9,000 of those overseas members are based in foreign markets. Half of these are in Asia. Next, I would like to introduce Nishith Desai, who is an international dispute resolution and international practice at Nishith Desai Associates. A senior attorney with the firm, Nishith specializes in bringing the highest levels of analytical and innovative input into cross-border corporate or regulatory investigations, while also leading the corporate and securities practice of the firm. Nishith's experience in legislation includes representing clients as counsel in a host of complex cases, including investment treaty arbitrations, commercial disputes, those related to shareholder agreements, international trade, and contractual disputes. Next, Kabir Dugal is a senior international arbitration advisor at Arnold & Porter. Kabir specializes in international disputes, including investment arbitration, commercial arbitration, and public international law disputes. In practice, he acts as an arbitrator, mediator, and counsel. He is educated at leading institutions with common law from Oxford Law and currently Harvard, civil law from Leiden Law, and international law from NYU. And last but not least, Alipak Banjari is a leader of the international dispute resolution and investigation practice at Nishith Desai Associates. He holds a bachelor's degree in law and a master's degree in international commercial law from the University College London. He represents clients in a wide range of services with a special focus on cross-border and complex litigations and international commercial arbitration. So that's the panelist. And I forgot to mention that I am not a qualified lawyer. I am a chartered accountant, so I'm very glad that this is a free webinar, as with one QC, 5 lawyers, and an accountant. That's a pretty large hourly bill. Vipak, I'd like to hand over to you now, please, to take the next session.
Hi. So thanks a
Yes,
lot.
we can hear you now.
Yeah, thanks a lot, Chris, for setting the background and the, the issues which led to this webinar. I think it is definitely very timely, and I think it's just, a first amongst many knowledge series that the UK IBC and, Nishith Desai Associates may, do for the kind of collaborations and the workflow which we are going to see between UK-India corridor. And who can be better than Mr. Salve to, give us a special address on that. So without taking too much of time, I will straight away, go to Mr. Salve. From, India perspective, Mr. Salve, we have seen huge amount of legislative amendments since last 7-8 years. I think it started possibly with Companies Act of 2013, overhauling the 1956 Act, bringing very different form of corporate governance in terms of shareholders responsibility, board of directors responsibility, and defining fraud as part of Companies Act, and a lot of those amendments came in. Then we also had our Insolvency and Bankruptcy Code, which in a way brought many different legislations into one code, making restructuring and bankruptcy processes much simpler in 2016-17, and then it was implemented over a period of time. We also had our 2015 Commercial Court Acts, introducing for the first time Commercial Courts Act, maybe somewhat similar, or at least taking some guidance from the UK commercial courts as well. Uh, and the seminal changes in Arbitration and Conciliation Act, where post 2015 amendment, we have seen huge amount of positive jurisprudence based on those amendments so far as Arbitration Conciliation Act is concerned. Also, Chris mentioned doing business in India and enforcement of contracts index, and the amendments in specific relief act bringing specific performance of a contract to the core also was one of the reasons why India jumped on doing business in India and enforcing contract listings. So I think there has been huge amount of activity since last 7-8 years. But we just wanted your take on this. Are we at least on the right direction? Is this enough? Are we even, we have just started, or we are in the middle of the path? What more needs to be done? What are the major gaps still left in the legislative amendments that India will look to do in the near future? What would be your view on that?
Let's break it down into the 3 or 4 separate elements which you've spoken of. First is the amendments to the Companies Act, clearly in the right direction. I think we have a fairly modernized version of company legislation now. And it's more a question of how it works out. What we need for making India a commercial hub and a real commercial center is a sensible way of working the Companies Act. The mindset in India of the department which administers the Companies Act is still not that of a helpful partner to business, but that of a suspicious regulator. Now that mindset has to change, because in all developed countries, if you have a problem, go to your regulator and say, I have this doubt. What do I do? And you get an answer. In India, nobody will give you an answer. They only wait. And if you trip a wire, they prosecute you. Now that mindset has to change. This colonial mindset has to change. The same is the problem about the arbitration law. We have changed the arbitration law. We have got all this going. 4 weeks back, I was opposing the admission of an arbitration appeal. And if you read the arbitration appeal, there was not a single ground challenging the award on a question of law. It was like a first appeal from a judgment of a court of first instance. And what happened? The court admitted it. Now, today we have statistics. In fact, a public interest litigation was brought in the Supreme Court that the entire infrastructure industry is paralyzed for want of funds. It is paralyzed for want of funds because A, you don't get paid when you're doing government or public sector projects. For the person sanctioning your payment is concerned that he will be held up. Go into arbitration, you get an award. That award is challenged all the way up to Supreme Court. And in the meanwhile, your money is not released. So your cash flow is completely thrown off the charts. And then the government of India comes with a notification to obviate the problem by saying the money will be released on 75% bank guarantee. Now, for all mid-sized businesses, releasing on a bank guarantee is not releasing at all, because the bank says, give me the amount as a deposit. So you're running the double risk. You take the money, you're paying the bank holding charges. And tomorrow, if you lose the case, you pay the money back with interest. So you don't get the money, but you pay interest for it anyway. Now, these are hard realities which somebody has to sit down and work out as to how are we going to work. And most of all, I think the judiciary is failing us. Why should the courts encourage these kind of frivolous challenges to arbitration courts? Let's take the commercial courts. I'm sorry to say India's foremost commercial court is the Mumbai High Court. What have they done otherwise other than changing the nameplate? We don't have more judges. We don't have more time. The pressure of work is still the same. So, these are, our laws are completely keeping pace. The other institutions, which is necessary to make the laws a living reality, they have not kept pace. The one exception appears to be the insolvency law, which thanks to quick judgments of the Supreme Court, at least seems to be working. And there, because the banks are banging on. That is why I think it seems to be working. But other than that, we need now to sit down, the government needs to sit down with the business community and find out ways of cutting through the maze of the problems and making things workable. And I will close my comment by saying this. There is finally a growing understanding that expeditious dispute resolution is an essential part of a good commercial center. India can never afford to have this reputation continue, that dispute resolution is one thing conspicuous by its absence in the Indian system. And I'm sorry to say, as of today, the delays of our system are such that expeditious dispute resolution is still a bit of a distant dream.
Thank you. So, yeah, Oliver. Thank you so much, sir. So my next question will be on judicial review, one of your favorite topics. So we have seen that in some of these legislations, there have been gaps in legislative drafting. You mentioned IBC. Of course, there have been plethora of judgments on Arbitration Act, IBC, where the Supreme Court or various high courts, they have really set out the law. In your respectful view, do you think this is a judicial overreach? Have they crossed the boundary, or maybe this is the right way to deal with the situation?
Let's be clear about the judiciary. The role of a judiciary is partly cultural. You cannot say an English court will not do this, an Indian court will do this. Each court works within its own cultural context. The English Supreme Court also, see what they did when Parliament was dissolved. 30 years back, could anybody have ever thought bringing judicial review against a recommendation of the Prime Minister to prorogue Parliament? Unthinkable. Today it happened. So every court keeps redefining its limits of its jurisdiction depending on their own cultural milieu. The US Supreme Court will never do what the UK Supreme Court does. The UK Supreme Court will never do what the US Supreme Court does. So, it's not really correct to try and judge whether the Indian Supreme Court has overreached, comparing it to what in a similar situation some other highest court of some other country would have done. With that caveat, our Supreme Court has always ironed out creases in the law. And I think all that the Supreme Court has done in the IBC judgments is ironed out a lot of creases. Now see how fast things have gone. If the Supreme Court had said, well, we see there is a gap in the law and we cannot address it, the things would have fallen off. I'll tell you one case where they did not. In ArcelorMittal, they realized that the problem of putting too wide an interpretation of 29A would virtually mean that somebody who has a 3% share or a 4% share, otherwise in deep pockets, gets knocked out from a resolution process. And the timing and the other things, but they said, sorry, this is something we can't fix. This is for Parliament to fix. So it depends on a particular issue where you can say this was a step too far or this was a step which they should not have taken. But with that, and that is true of any court. Why just the Indian court? I mean, there are so many criticisms of other courts in other jurisdictions where academics have said this was a line crossed by the court. But I don't think the Indian courts have done wrong. In fact, I think they've done the business community a service by trying to iron out whatever creases they could without rewriting the law.
Yeah. So no, I just had one follow-up question on this before. I think Sharina is a question for you. But is this a good time for Indian legislation or legislators to also have a better system and process when they are legislating new laws? Because at one end, we are seeing huge number of laws getting legislated and amendments getting, effective. But on the other hand, as you said, there has been few gaps and creases that the judiciary had to intervene to solve right in the first, second, third year of those laws. So it's not like after 5, 10 years, some laws require a different interpretation or a different view, right? It was just in the first, second year of amendments, both in arbitration, IBC, and even Companies Act, the judiciary had to intervene to iron out those creases. So maybe your take on the process of legislations, and do you think there is anything better or more that India could do to give that confidence for at least the new legislations and the new laws which are going to come into effect in the near future?
That's a difficult one, and it's a difficult one for the reason that there is nothing again wrong with the process which is in place. It is the way in which it is actually being worked. Without getting into a political discussion, let me tell you, I've been in this game now for 4 decades plus. I've seen Parliament in 80s and 90s, and we've dealt with cases of 80s and 90s, where there was a clause by clause discussion in Parliament. Members of Parliament used to get up and make interventions. Why are UK laws better drafted? Because if you see, there is a first reading, then there is a second reading, then it goes to the Lords. The Lords have the first reading and a second reading. There are crossbenchers who actually sit across with the government and discuss laws. Now, did we have that process in place? Of course we did. I don't know how many people know when that SARFAESI law, that securitization law, was passed. The law was introduced in the upper house, or Rajya Sabha, by Kapil Sibal, the leader of the opposition, because it was a law which the two sides got together and said, yes, we need to do something by which banks can securitize debts, and wrote up that law. And the leader of the opposition presented that legislation. Now, that is a culture we need to bring back into place. You have laws which are politically volatile, put them to one side. You have laws where everybody is on the same space, the commercial laws. And you should have a more vibrant, once we get back into Parliament working, vibrant discussions on commercial laws, on a clause by clause discussion, it will come back, and there is no other way. There are no shortcuts. There is no other way.
Sure. Sharina, you want to take it from here?
Yeah, but Mr. Salve, you are the most sought after counsel on the UK-India corridor. Having seen India and UK so very closely, could you comment on the key differences in perspectives in managing an Indian dispute from London?
You'll be surprised how many Indian clients opt for managing Indian disputes from London. I have recently come across at least 2 cases where a Delhi seated tribunal, in theory, has actually sat in London and has had non-Indian lawyers on both sides. The reason is Indian arbitration culture is building now. Look at all the arbitration practitioners around you. Very few of them are gray-haired like me. You have people like Vyapak who have, for the last 10, 12 years, brought a new skill set to Indian arbitration, who are bringing in international arbitration practices to India. And I'm sure as this evolves, so will client confidence evolve. But today, there was a feeling, and let me be very brutally frank here, there was a feeling that Indians always got the wrong end of the stick in international arbitration. Then came an understanding that The reasons why Indians always possibly felt short in international arbitration is the way culturally we handled an arbitration case sitting in India, and the way English lawyers handled it, or the American lawyers handled an arbitration, was very, very different. Now everybody realizes arbitration is not something which you do on a Saturday afternoon when you have no other work to do, or after 4 o'clock in a hearing between 4 and 6 o'clock lasting for 3 years. Arbitration is something which you do like a commercial court trial. Start to finish, prepare, cross-examine, and get on with it. So this culture is now coming in. I have seen lawyers now seriously doing arbitration practice. We have, for example, you have Sikho Mukhopadhyay in Delhi, who 90% of whose practice is doing arbitration work. You have lawyers in Mumbai, so many of them, 90% of whose practice is doing arbitration work. You have your star law firms, one of them is NDA, who has now a arbitration practice. 20 years back, which law firm had an arbitration practice? Nobody in India. So this culture is changing, but the UK firms have a head start on this. UK firms were doing in the 70s and 80s what Indian firms have started doing in the turn of the century. So that is why handling litigation is easy. The second important thing which has happened, the UK-India corridor, over a period of time, London has become India's favored arbitration destination. Singapore and London. Early, back in the day, it used to be Geneva and Paris. I remember as a younger lawyer, all the arbitrations we did were either Geneva-based or Paris-based. If London and Singapore, and London to a large extent, has become a choice destination for arbitration, and now there is such a large Indian diaspora in the legal profession in the UK, that you will have greater confidence of the Indian clients going to the India desk of a UK firm, where they have lawyers who are familiar with the Indian context, with the Indian culture, with the way Indian things work, and conduct the litigation and do it effectively. The advantage you have is you save on a lot of costs if you have a local firm. If you have a local barrister, you save on costs. If you have somebody coming from India all the way to London to stay, travel, etc. So this is why London has become a very attractive destination for dispute resolution.
Sure.
Thank you.
Yeah, thanks a lot. And one very last question. I know we are running a little short of time on this, but very last question on, we have this whole new concept of smart city, the gift city coming up for attracting investments, and maybe possibly some other states also may follow the suit and create city countries in countries, like what other countries have done in the past to attract the investments and deal with those investments in a little better way. Do you think that's a right approach and we are doing enough on that front? Maybe very short view on that, and then we'll move on to the
yes. See, we need India is too vast a country with too much diversity. We need to consolidate and have areas sharply defined in which we are willing to accept foreign investment and in which a foreign investor has clarity. See, there's nothing worse for investment than uncertainty and lack of clarity in rules, regulations. A business person wants to know upfront, is there going to be a 20% tax? Fine. Then you do your economics and work it accordingly. No business person likes to invest saying maybe there's 10% tax, maybe it's 30%, maybe it's 25%, but then you can go to a court or you can go to a tax tribunal. That is not how you plan an investment. I would rather know upfront that yes, I have a 20% tax. I would rather know I can do this and I cannot do that. I can build so much and I cannot build that much. So clarity is the fundamental defining feature for attracting investment. And I am so happy that the government finally withdrew the Vodafone, saying this, recognizing virtually in the statement of the finance minister that it has been a damper on foreign investment. I think that is a very important statement, apart from taking the law away for which they'd already lost the international arbitrations. An acknowledgement that a retrospective legislation acted as a negative in the environment which you seek to invite investment, I think is a very important admission on the floor of the House. And if this mindset continues, I think it will help India hugely in convincing foreign investors, whether it be smart cities, whether it be zones, clarified as to what exactly is the law, what exactly is allowed. It has to be black and white. We have to reduce the grays in India and bring about a non-hostile enforcement system. If we can achieve that, instill that confidence, I think India, otherwise, seeing the way India has potential for growth, India is a great investment destination.
Sure. No, thanks a lot. Thanks for your very, very detailed and very clear views as always. Over to you, Chris. I can't obviously thank Mr. Salve more than what but I hand it over to you to do the honors.
Perfect. Thank you very much, and thanks, Mr. Salve, for your honest and open comments. I think there was a couple of things in there which really sort of struck a chord with UK IBC, particularly in terms of your final comments around foreign investors just wanting clarity and that policy certainty, which is extremely important for any region that's looking to attract foreign investment, and of course reducing that grey area. As I mentioned before, the bureaucracy and legal issues continuously is our #1 challenge from when we do our ease of doing business survey for our businesses. I think also what was interesting was your explanation of there needing to be a shift in the culture of the regulators from the suspicious regulator looking to fine to supportive and helpful partner. And of course, your conversation around how the insolvency laws are really starting to work and starting to help to bring that investment. And finally, of course, that whole area of dispute resolution becoming more of a skill set now within the Indian law firms. I remember about a year ago listening to some of the experts in the UK saying that many of the judges now will not actually hear a case unless it's already been to arbitration or mediation in the UK. And I think that's extremely important to be able to, again, help attract that foreign direct investment. That there is that, rather than waiting 2 to 3 years for a legal case. So again, a huge thank you from all of us for your time today. And back over to you.
Yeah, thanks a lot. And moving to our next segment, which is, I think, negotiating a contract in India. Maybe I'll bring Alipak and Sharina on this. And Alipak, if you can give very quick perspectives on what are the Indian issues or Indian legal matters that one needs to look at when you are entering into a contract with an Indian party. And then, of course, I'll come to Sharina for sharing her tips for a UK perspective as to, what are the do's and don'ts. So, Alipak.
Hi, thank you, Vyapak. So I think for the purposes of our discussion, I've identified 5 commonly negotiated clauses, and then I'll try to throw some light on them. I think the first thing which comes to our mind is the governing law clause in any agreement that gets negotiated. I think there's a lot of discussion as to which law should govern the agreement, whether it should be by Indian law or whether a foreign law should be applied to a dispute, applied to the parties when they contract. For this purposes, I think it's important to understand some of the differences between the Indian law and the other scheme of law which is being applied. Typically, what we have seen between UK and India corridor, either English law is chosen elected as a governing law or Indian law. Foreign clients, they're very comfortable with Indian law governing the agreement. It could be a JVA, it could be a share purchase agreement. There may be some reluctance in agreeing to an India seat if the parties decide on our. But insofar as the choice of law the agreement is concerned, Indian law is fairly respected. Yes, there are differences. Like for example, while claiming damages under English law and Indian law, there are differences. Indirect loss cannot be claimed in India, and the statute specifically provides for that. In UK, there are differences. I mean, in the sense, there are case laws, and then it gets governed by them. So there are some differences, but broadly, Indian law is applied. Second is, in what circumstances and how do you apply? Like, there are different business models, right? If the UK company was to invest in India and form a wholly owned subsidiary, and the Indian subsidiary of the UK company, they enter into a contract with a counterparty, then the question is, can you elect a foreign scheme of law when two contracting parties are domiciled in India? Now, this again is a very critical question which has been addressed by some of the court judgments. And this in this instance, the Supreme Court recently in a case has opined that insofar as arbitration is concerned, there may not be any impediment in two Indian parties governing the arbitration by a foreign scheme of law, or to electing a foreign governing law to determine their dispute. Even Delhi High Court had opined on this issue earlier. But the issue is, if two parties elect on a foreign law, then of course in the court proceedings there may be a problem, because in India, if you elect a foreign law, then that can be adjudicated as a matter of fact. Indian courts cannot obviously opine on a foreign scheme of law. Then another point to be considered over here is, not everything can be covered by the governing law clause. So there are statutory rights and there are rights in personam. So to the extent the rights in personam are concerned, that is the contractual right, while you can agree on a preferred mode of resolution or a choice of law to that extent. But insofar as the statutory rights are concerned, for example, the Insolvency and Bankruptcy Code, the Companies Act, then you will not have the ability to elect a particular choice of law. So these are some of the nuances on governing law. Next, I'll come to the jurisdictional clause. The debate between arbitration versus litigation, Vyapak and Sharina will talk about it in some time. I will not labor that point at this point. But yes, I want to talk about exclusive jurisdiction clause. Yes, it is possible. India is a vast country with many high courts. Yes, it is possible to elect a forum within India where you agree to litigate your cases. It has to be drafted in a particular manner. One should use words like exclusive, solely, and so on and so forth. If it is an arbitration, you should very carefully decide your seat of arbitration, because the seat of arbitration determines the territorial jurisdiction of that particular court. For example, if the seat is in Mumbai, then the Mumbai courts will have on the overall arbitration. Next clause, which I wanted to throw some light, was non-compete and restrictive covenants. Yes, it is possible in India to include a non-compete clause. The Indian Contract Act recognizes that goodwill can be protected, but yes, these clauses will have to be very reasonable. If you have such a clause, it's important that the definition of business or what you're trying to preserve is carefully defined. And there needs to be a specific duration where the clause will operate. What is not allowed is a restrictive covenant clause for perpetuity. There are various court judgments on this issue. So long as there is a specific duration and the definition of business is properly drafted, these clauses are enforced. We have seen many arbitral rulings also on this point. The next clause would be limitation of liability clause. Again, this is a clause which is built into an investment document to limit the liability in case of a breach. That we don't have too many court cases on recording the enforceability of these clauses. But yes, there is a Delhi High Court judgment which have said that you cannot restrict the liability, but that happened in case of a government contract. It was a one-sided contract. Then there are counter judgments by Bombay High Court where they have categorically enforced limitation of liability clauses. This is a very important tool and a clause which is heavily negotiated by the promoters and the investor, which is something which can be used. And finally, indemnity. In Indian context, a clause on indemnity is very common and and it is negotiated properly. Again, for indemnity, it has to be very specific on what is getting covered in the indemnity. Then the threshold needs to be mentioned. So under what circumstances the indemnity will apply. Often we see that there is a de minimis cap prescribing a financial limit to when the clause gets triggered. Then, of course, there's a detailed claim process drafted in the investment document where it prescribes in the event of a breach how one should go about claiming the indemnity. And then the limitation around it, what could be the time frame from the date of effective knowledge of certain breaches. These are clauses which we have seen in a lot of investment documents between UK and India, and these clauses have been arbitral awards have been passed based on such clauses, and they have been enforced by courts as well. With that comment, maybe I'll request now Sharina also to provide her thoughts on, from a foreign practitioner standpoint, which are the key clauses which she commonly sees that is getting negotiated by our colleagues in the transactional team.
Thanks, Ali Pak. It's bizarre because you and I, there are two topics that we've touched upon which are the same. So when I look, while India and English law share a common origin, they're obviously far from the same from having different cultural norms to practical considerations of different jurisdictional systems. And while India and UK are both countries rich with opportunity, the enthusiasm felt when drafting a contract has to be tempered with the practical realities of the different legal system. So when I'm thinking, and that's with my dispute resolution hat on, for 5 tips for foreign counsels negotiating contracts involving India, the 5 tips I would think are defining the dispute resolution process and the choice of law, as you've touched upon, Ali Pak. The second is, again, as you've touched upon, considering litigation or arbitration as a form for dispute resolution. Third is considering questions around enforcement. Fourth would be considering using intelligence or asset tracing companies. And the fifth is to consider anticipating contract termination. So moving to the first tip, which is defining the dispute resolution process and the choice of law, according to me, that is one of the most important elements in any transnational contract. And I see you would obviously think the same as well, since you touched upon it. And you'd say that I, being a disputes lawyer, would obviously say this. So, but I have seen too many badly drafted clauses drafted at Friday midnight before the contract is signed, or worse still, completely overlooked as it's ensconced in the last few pages of the contract. And then the fun begins when parties are no longer able to see eye to eye because they overlooked the disputes clause. And suddenly that overlooked disputes clause becomes the most important clause. It ultimately determines where the parties may be able to successfully prosecute claims, defines the rights and remedies of parties, and one's ability to seek and recover damages. And hand in hand with the dispute resolution clause is to consider the law governing the transnational contract, and usually between UK and Indian parties, I have seen that generally in English law is preferred, is the preferred law. So tip number 2, litigation or arbitration. That is the question. I think one of the cornerstones of a well-drafted dispute resolution section, including where one of the parties is from India, is that it should specify how disputes will be resolved. And that begs the obvious question, which is the choice between litigation or arbitration. Again, to me, the obvious choice is always arbitration. It provides speed, neutrality, freedom of choice to parties, and most importantly, ease of enforcement. Litigating in any foreign jurisdiction under foreign laws is generally never considered a good option for any foreign party. Many a times I've seen foreign parties simply walk away with a loss rather than try to maneuver themselves through the quagmire of foreign courts. And when it comes to India, another added disadvantage to litigation is that the Indian courts are overburdened with cases, as Mr. Salve touched upon. In fact, while it's impossible to get an exact figure, it's believed that there is a current backlog, and I was trying to do some research on this, of over 40 million cases between India's various courts. So litigant has to wait a very long time to actually see any form of resolution to its dispute. India has also been noted by the World Bank's Doing Business 2020 study for cases taking almost double that of OECD countries for a typical litigant. And what's more, the situation has gotten worse with the pandemic. The High Court saw disposals halve during 2020, and Supreme Court's decisions were only a fraction of what they were the year before. So foreign companies must bear this in mind when negotiating contracts. And I think when it comes to that question of litigation versus arbitration, arbitration has to rule with looking at these kind of drawbacks of litigation. The third tip is about enforcement, and linked with choosing arbitration as being the means for dispute resolution is to consider the question of enforcement of a successful award. Although India was not historically considered an enforcement-friendly jurisdiction, the government and the judiciary have taken significant steps to address this, and India is increasingly becoming enforcement-friendly. In fact, the Supreme Court has issued a number of judgments clarifying the narrow scope in which courts can refuse to enforce awards, and the prevailing trend is that the award is likely to be upheld and enforcement effected without question. For instance, I know there was a recent Supreme Court case of the Government of India versus Vedanta, and the court enforced a $278 million award against the Indian government for recovery of costs under a contract based in Malaysia, governed by Indian law, seated in Kuala Lumpur. So although there is still a reluctance, and I see this with my clients, of foreign parties to completely trust the Indian legal system to enforce awards, I would say India is slowly but surely becoming reliable in its approach to enforcement. And foreign businesses have to be aware of this when drafting their arbitration clause, particularly where the bulk of the assets of the other party are in India. Touching upon tip number 4, and I've just alluded to that, is using intelligence agencies and tracing agents to trace the assets to understand the lesser known facts about the company are not in the public domain. Asset tracing was something that was seldom used by clients a few years ago because they just thought it was an added cost burden. But I've actually seen this field grow exponentially recently, and particularly in relation to India. So besides the big 4 that offer the service, many individuals who have held positions within governments or regulatory authorities have set up agencies and are supremely helpful with trying to find out information. The obvious point at which one considers tracing assets is after a dispute has arisen, or sometimes as late as at the time of enforcement. However, getting this information right at the start when building the contract assists in drafting of the contract itself, the dispute resolution clause, to cover all the eventualities, understand the places where the other party has assets besides India, what are those assets, and if those assets are in enforcement-friendly jurisdictions. And finally, tip number 5 is anticipating contract termination. Obviously, no one contemplates divorce before getting married. But unfortunately, in the business world, it is important to think far, far ahead into the future and consider ways to protect your company and assets. And in this regard, it's important to specifically outline the steps necessary for a valid termination with or without a material breach of the agreement. So, for example, questions are of how far in advance must the counterparty be notified? What are the notice requirements? Does it have to be in writing? Who should the notice be addressed to? How should it be delivered? For example, does it have to be sent in hard copy or is sufficient? Importantly, it's crucial to define what situations might be grounds for termination, particularly before the end of a defined contract term. This would involve identifying and assessing the risks and how to reduce them, and anticipating what could happen if things go wrong. So I therefore may seem like the voice of doom, but unfortunately, disputes lawyers are the ones that need to pick up the pieces of parties that have entered into contracts with rose-tinted glasses. So I hope, Alipak, and Vyapak, that's answered your question. And now in return, Alipak, I move on to the next section on data privacy, and I have a question for you. Can you touch upon the recent developments in India in relation to data privacy?
Thank you, Sharina. So, in the last couple of years, there have been a lot of coverage on data protection issues, if I may put it that way. But ultimately, nothing has happened. That is the short summary. Since 2017, we have been hearing that there will be a new law on data protection. Insofar as personal data is concerned, a bill was introduced in the lower house of the parliament, but nothing happened after that. And then, as things stands today, there is no law on this in India. But I mean, there are also reports to suggest that maybe in 2 or 3 months, a new bill will be introduced in the parliament and will have a law on regulating data protection by early next year. As regards non-personal data is concerned, even that is at a very early discussion stage. No bill has been introduced, nothing has happened. Now, if we look back slightly, in 2017, the entire discussion on a specific law on data protection started with the Supreme Court judgment, which recognized right to privacy as a fundamental right guaranteed by the state. That was the starting point, and then we have made some progress, but we are still maybe a couple of months away from a new law which we are going to see. Now, in terms of a practical tip, when there is no law, how do you secure your rights? What many clients, what they do is they'll agree on a very stringent data protection through confidentiality clause in their investment agreement or in their contract, which of course can be enforced because there's no prohibition in enforcement of such clauses. So that's the practical way to go about it. But yes, a specific law on this subject is right there on the agenda, and which should be available to us very soon.
Yeah, thanks a lot, Alipak, on that. And I think only point I wanted to add on that was at least we have some amount of guidance on personal data under the Information Technology Act rules, which at least looks at personal information to be protected. Of course, it's very, very limited, but at least there are some rules which give some guidance on personal information like your medical records and other things which can be still protected under those rules. Going into the next topic, which I think I can possibly give very quick overview on, is where India stands on anti-corruption and bribery laws. Now, unlike the understanding of Foreign Corrupt Practices Act in the US or UK Bribery Act in the UK, I think India has still not promulgated or have a law dealing with private bribes. In sense, private to private corruption or private to private bribe is still not been looked at, or at least been monitored. What we have is our Prevention of Corruption Act, generally called POCA, which deals with bribe to public servants or public bodies. But what significant things have happened in that law in last 3 to 4 years post the amendments is that for the first time, the introduction of a section which now exposes the bribe giver. So earlier what used to happen was only the bribe taker was prosecuted under Prevention of Corruption Act. Now bribe giver is also directly prosecuted, which means private parties who are indulging in those kind of corrupt activities can directly be prosecuted, which is a huge shift in the law. And therefore private companies establishing either joint ventures or branch office or their subsidiaries need to make sure that their processes and compliances are up to date, so that they don't trip on Prevention of Corruption Act. And two, there is a clear amendment made in terms of vicarious liability for the corporations for the actions of the employees. So now no longer you need to rely on general jurisprudence on how companies or the corporations would be liable for the actions of their senior management and vice versa. Of course, there are certain safe harbor provisions included in the law, but you need to be very careful that you don't trip on that. So those were two topics on data privacy and anti-corruption that we want. Jokingly we always say that while we believe in reincarnation, we don't have to finish our cases in our lifetime. But that's not good for business. Country to introduce 18 months timeline for arbitrations as a statutory period. I have not seen such stringent timelines under law for completing arbitration. And therefore, in my view, we have done quite a bit in terms of amendments, both in terms of process of arbitration and enforcement of the awards under the arbitration, including the approach of judicial intervention has completely changed to judicial support. I think there is huge amount of jurisprudence leading to conclusion that the judiciary has completely changed. Question that I was asking you was, have you seen a shift with Indian parties looking at mediation? While we have spoken a lot about arbitration and litigation, but what's your view on mediation in India?
I definitely have seen the shift, and I think parties in India are becoming much more alive to the possibility, whereas in the past they never even used to ask the question about mediation. But I think India needs to do more to capitalize on this form of ADR. It's cost effective, it's time efficient, particularly with COVID and companies having a cash flow issue. I've seen more and more of these questions coming up. And I know that the Indian courts have done, are leading the way in promoting mediation. And there are various mediation centers that are opening up across India. So, my clients are seeing the benefits of mediation. And, not only, as I said, is it cost and time saving, but also many a times it saved the relationship as well between the parties because it's so much less adversarial. So I've personally seen the sea change in general counsels asking the question, wanting to know more about the benefits and actually actively considering mediation as a step, even when they're drafting their international contracts.
No, thanks a lot for that. And now bringing in Krina, I think thanks for listening to us patiently for such a long time. But I think there are two very important topics Sharina has given her views. One is on the enforcement of foreign awards. And I know you have been part of certain studies and research, including certain statistics on that. So maybe if you can throw some light on that. And also, without any intervention, maybe you can also thereafter answer your views on, the Singapore Convention on Mediation and how does that change the landscape so far as, UK-India disputes are concerned.
And fascinating listening to the discussions, which confirm the fact that India is now or has entered definitely a new stage for dispute resolution and business. And we can see this, as you mentioned, from the statistics on enforcement. I think Sharina summarized quite well the past and the present and possibly the future of enforcing foreign arbitral awards in India. The study that we are currently is an empirical survey of the court decisions that we have in Kluwer arbitration database. As you know, it's a wealth of court decision related to arbitration practice, either set aside or recognition and enforcement. This will be public next year, I think in spring. So we're currently looking at data, and for India, it's very important to note that the recognition and enforcement in India in the past, or at least until 2-3 years ago, is almost inexistent. So what we get from the Indian courts on recognition and enforcement of foreign arbitral awards is almost inexistent. We see, however, as Sharina was mentioning, important developments and very pro-arbitration, supporting arbitration in the past years. Another the recent decision of the Supreme Court is the one on the emergency arbitrator decision. And I think India, at least from this point of view, is leading the practice, and it should continue this way. Now, also from the review of these cases we have in Kluwer arbitration database, it is interesting to note that the enforcement involving Indian parties, and I think this is also important when we discuss the international businesses and more traditional relations such as the UK-India corridor, where do Indian parties go to enforce awards? Or where are awards enforced against Indian parties? And of course, we refer to asset tracing, and obviously this is a decision that is based on the peculiar facts of each arbitration. But we see increasingly parties going to the US, to Australia, to Singapore, but also less common jurisdictions such as Colombia, Finland, Malaysia, and Canada. This says, and in terms of how often Indian parties are plaintiff or defendant in this enforcement proceedings, is interesting to note that it's almost half-half. So it's not that Indian parties are always the award debtor. They're in half of the cases, they're the award creditor. So that's interesting to note. And this reflects the fact that India currently is a capital exporter country. And I think we'll go to this a bit later when we discuss the investment, but it's also something that Mr. Harish Salve mentioned in his intervention. So that would be on the statistics. When it comes to mediation, and this is also part of the discussion of how India is doing business nowadays. So it's not only trying to attract investments, but also trying to export investments around the world. Mediation, of course, as Sharina was mentioning, is a very effective dispute resolution mechanism. The UN Convention, the Singapore Convention, or formerly known UN Convention on International Settlement Agreements Resulting from Mediation, has entered into force on 12th of September 2020. It is important to note that India has signed the convention on 7th of August 2019, the very day when it was open for signature. So we can see the appetite, at least for India, to be part of this major development. And for the audience, but I'm sure that everybody's familiar with this already, the Singapore Convention is trying to do for mediation what the New York Convention does for foreign arbitral awards. It is also important to note that it only focuses on commercial disputes. I would say that, leaving aside the fact that it facilitates the enforcement of mediated settlement agreements around the world, what the Singapore Mediation Convention does is to raise awareness, or even better, not only raising awareness, but putting a big green flag saying you should trust mediation. It has the seal of the UNCITRAL, of the UN, of all the signatory states. Mediation is an important dispute resolution mechanism around the world, and it should be trusted. So all the probably, and this goes back to the culture as we discussed today, raising awareness, educating the businesses, educating the lawyers. This will take a bit of time. What I could see, and this goes back to my academic practice, I see students coming from India that are very interested in mediation. And at least in the past years, numerous students who are very interested in understanding how mediation works and trying to promote, to write about it, and going back to their jurisdiction to perhaps use it actively. What I think is missing in India at this point, and probably you have Vaipak and maybe Alipak, you have a bit more knowledge of what's happening with the ratification process of the Singapore Convention. But what I can see from outside is that India should promote a uniform statute for mediation. It is important to maybe discuss openly what is the difference between conciliation and mediation, and perhaps be a bit bold in the approach and have the same attitude as the UNCITRAL had with the Singapore Convention, and subsequently dropping the conciliation term and relying only on mediation. And now we have the mediation law, model law, and we're going to see the mediation rules. So perhaps a good shift and a positive message to be sent to the audience and to the users would be focusing perhaps only on mediation, or trying to make clear what is the distinction between conciliation and mediation. So that would be on my side, and probably I'm eager to hear from you. What is the progress on the Singapore Convention?
So we have been part of certain committees and public discussions on mediation law. It's around the corner. I think there is too many things on the plate of the government, so we can't in a way say how much time it would take. But at least my sense is that they are very serious about the law. They want to bring a specific and dedicated law on mediation. There is a lot of work going in the background, and we'll see a significant progress soon. But before I come back to you, Krina, again, I'll just answer two very good questions. One is from our friend Ben Giaretta from London. I think he has asked about the GIFT City and the International Arbitration Center, which might come up there as per the announcement. Now, I think India, obviously, unlike other countries, we can't have just one central arbitral institutions. We are going to have many different arbitral institutions, because there is huge amount of disputes which are waiting for getting resolved, as Sharina also mentioned. So yes, there has been a proposal. Not much has happened, at least as per the public information. Maybe they may adopt certain rules for the existing arbitral institutions, but that is something in works, and we obviously will update the group and the participants as we hear more about it. And two, I think from Tina, there is a question on preference from arbitration versus litigation perspective. There is a clear preference on arbitration. I think there is no debate about it when it comes to India. So that's where we are. But I think last we have like 3-4 minutes left in the session. Maybe we'll extend it by 2-3 minutes. But Trina, I think Mr. Salve also talked about a very significant development on BITS disputes, and Parliament making a statement that some of the retrospective amendments leading to BIT losses were not in the right path so far as India is concerned, from doing business in India and attracting foreign investments. So there has been last 10 years has been a big churn of BITS disputes so far as India is concerned. From zero, we had like more than 20. Maybe your quick 2-3 minutes view on that. Sorry for that little short time, but I think it would be good to hear from you.
No, it's part of the discussion, obviously, and especially now in the context of UK's Brexit and increasingly UK entering into investment treaties. And of course, India, as you said, for those who remember in the early 90s, with the liberalization policy, India was at the forefront of investment law, promoting and protecting investments. And you rightly mentioned that we had a bit of a development in the meantime. I would say that it started with the White Industries case, which quite an unfortunate background of the case and unusual. But we had that increasing attention from the Indian government when it comes to the bilateral investment treaties and investment protection in general. And of course, as you mentioned, followed by the tax cases, Vodafone, Cairn, Vedana, and we still see developments on this side. And Mr. Hari Salve was rightfully mentioning that what investors expect is to have this transparent, this clarity when they're investing in a country. And I also want to highlight the fact that as I mentioned, India is not only a capital importer state, but also a capital exporter nowadays. And these investment treaties are essential not only for attracting investments, but also for protecting Indian investors abroad. So what we could see, if we look in the overview at the cases, and we can include all of them, the less prominent one like Louis Dreyfus and so on, what we see is there was either a failure on the part of the judiciary or the Indian government through its legislator actions, which formed the basis of this investment arbitration cases. And we see even more recent development with the Cairn case, the PCA arbitration, when initially after the arbitral award was issued, and we're talking here about $1 billion award plus interest, half a billion in interest. We could see an offer at the beginning from Cairn to settle the case, which was initially refused. And I understand that now they're almost close to settlement in the developments. In the meantime, we count an appeal from India against the arbitral award before the Dutch courts. We also have the Vodafone case also in the background. So a lot of development and a lot of publicity for investments. What we had in the meantime was the new Indian model BIT 2016. And we have in parallel, for those who are familiar with this, the discussion in the UNCITRAL Working Group 3 on the reform of investor-state dispute settlement. And I participate in the discussion in the UNCITRAL Working Group as observer, and it's very interesting to see, and I applaud this. India has a very active representative in the discussions, and definitely it's not an approach of we want to wipe out ISDS. We want to see obviously a reform, and some of the position of India is obviously seen in the Indian model BIT. But at the same time, India has to, as Mr. Salve was saying earlier, it's you need to match the proposals that we have in the legislation with the conduct of the government and other state entities. And this is not typical for, it's not a problem of India, it's all the countries in the world. Is one thing that we put on paper and the other thing that we do. So we need to meet in the same point. When it comes to the BIT, I think it's important, the model BIT, and we already have BITs concluded based on this India model BIT of 2016, is to understand that investors have to pay attention. That is a peculiar approach of India. There is no fair and equitable treatment. We have customary international law now. The definition of investment is one that mirrors the Salini test. The investor has to contribute to the development of India, of the economy of India, and so on. So there are certain points which make the more recent approach to investment special when it comes to India.
No, thanks for that quick snapshot, and I'm sure this topic in itself can possibly cover one full session. But with the want of time, I think we'll possibly end there. But Sharina, if I can come as a last word from you, and we'll end with your take on the topics that we have covered. Sitting in UK, we are talking about UK-India corridor. We have heard Mr. Salve, who is possibly the most prominent figure when it comes to legal aspects between UK and India, and then Krina. What's your final view on the aspects what Chris was talking about, making the UK-India corridor very, very busy? How do you see everything unfolding in next 2 to 5 years?
I think it's a really positive outlook, actually, Vyapak. So I know I started when I was talking about with this voice of doom, but that was when I talked about dispute resolution. I think when you look at the India-UK corridor, business is booming, booming more than before. I mean, it hasn't even ebbed with the pandemic. In fact, I've just seen it increase. So I think it's a really positive outlook. I'm seeing parties collaborating more. I think the trade treaty is a phenomenal development that's happened. And I don't know, maybe in our lifetime, we may actually see the opening up of legal services for foreign lawyers in India. I never thought I'd see it in my lifetime, but there is a glimmer of hope.
So I think with that positive note and the tinkle in Sharina's eyes about practicing and arguing in India as well, I think we'll end this session on that good note. And thank you everyone from UK, London, and from India, various parts, joining this session and sitting through. As promised, we'll obviously continue sharing knowledge through webinars and also through joint writings with UKIBC and other institutions. So thanks a lot. I think we have already answered a couple of questions. There are still a couple of questions which we could not answer, but we'll make sure we send out emails to specific participants. And looking forward to seeing you everyone again. Thank you. Thanks a lot.
Thank you.
Thanks, Chris. Thank you.
Bye-bye.